I'm Danielle Stevens, the Executive Director of People's Legal Aid. I'm actually not an attorney, and I'm here to give you some general information about the eviction and debt collection processes and how they operate in Utah. And I also previously worked here in this community, overseeing our housing and homeless system. So very familiar with the area and really happy to be back here. As I mentioned, I'm not an attorney, so I am not licensed or permitted to give legal advice, but I can share with you general information. So like if you, sir, have questions about your specific situation, I'm going to keep telling you, call our intake line, but hopefully this information will help you better understand the processes and your specific situations. We're going to go over a few things today, and for the sake of time, I am going to gloss over some of these elements, but I really love this presentation to be a conversation, so please don't hesitate to raise your hand, ask questions as you have them. No need to wait for the end. I'm just going to do a quick introduction about PLA, how we were founded. We are not going to do the engagement exercise today because we're limited on time, but we are going to talk about the eviction process, and you should all have a roadmap in front of you that I will use as a tool as we talk through this. You can take this home, and we will also be sharing an electronic file with Cody so that they can print more if they have requests for this document. And we're also going to talk about eviction notices, the different types we see in Utah, what they look like. We're also going to discuss what it means when you get locked out of your unit as a tenant, as well as the debt collection and garnishment process, which does exist, and it's a whole other side of the eviction process that not everyone is aware about. And then, again, we have Q&A, but feel free to ask your questions at any time. So People's Legal Aid, or PLA, we're a nonprofit law firm. We provide free education and legal advice to Utahns with housing issues, as well as low and no cost eviction and debt defense. We're not currently statewide, but we do offer services here in Weber County. And we have three major areas of programs. The first is our legal services programming, and we provide legal consultations. So an example of those are when people call our line and they say, hey, I have a question about my lease, or my rent or my heat's not working, what do I do? Questions like that about your rights, your status as a renter. We will schedule you for a consultation with our attorney, and he can walk you through that process. We also provide legal representation, most commonly for what we call limited scope matters. And these are for a snapshot in time where we typically represent clients on what's called an occupancy hearing. And this is when a judge basically determines if you have a legal right to remain on that property. And we represent tenants in those situations. And typically our service with that individual ends after that hearing for that specific instance. We also do take cases for more extended service representation on a longer timeline. We pick up those cases based on merit and how supportive the law is to take that case through a longer timeline with that individual. And we were founded as a pandemic response, so we're only 2.5 years old, still very young. And I need to update some of these stats because I just ran some new data, but 60% of our clients actually identify as non-white, and the majority of those folks identify as Hispanic or Latinx. And that tracks with nationwide data around who evictions affect the most, and they disproportionately affect Black and Indigenous and people of color. And most of our clients are spending more than 30% of their income on housing, meaning that your housing cost burden, you don't typically have enough money month to month to cover other costs like your utility bills, food, anything else that you might need in your life. And most of the evictions we see in Utah are for late or non-payment of rent. And the truth is that when you don't pay your rent in Utah, there really are no defenses to prevent an eviction in that situation. And the majority of notices are a 3-day pay or vacate. And typically when we represent people in court because they didn't pay their rent, the most we can do for them is try to negotiate how much money they owe out of that eviction in the form of damages, attorney's fees, treble damages, etc., and try to negotiate down that financial obligation that can actually end up being really burdensome for people in the long term. Do you have any questions so far? Okay, this is our intake line right here. I also encourage you on the back table, there's a postcard sized document that has all of our intake info on it, and you can contact that phone number. It's textable to get assistance, and we also have an email address that you can reach out to if you need help. So going to this chart, the eviction process in Utah moves very quickly. And we're only talking about evictions right now, not debt collection. So if we're looking at this handout here, let's say as a renter, you sign an agreement with your landlord. This can also be a verbal agreement, which we see sometimes. A lease is not always a written contract. It can sometimes just be an oral agreement between the two parties. So you sign that agreement, and when you do that, you are in a contractual relationship with that landlord. The landlord owns the property. They're agreeing to grant you access to that property for the time period that is outlined in that contract. And at step 2, we see a problem arise. Maybe you haven't paid your rent. Maybe you violate the rental agreement, smoke in the apartment, and you're not supposed to, something like that. Or you break the law, which we see sometimes. There's an issue that happens that causes your landlord to want to evict you. And at that point, at step 3, they're going to serve you an eviction notice. And we sometimes get the question, is an eviction notice a legal issue? It is, but it's not yet a lawsuit. An eviction notice is a legal tool that landlords will use to try to remove you from their property. It is only when they file a lawsuit with the court that that eviction actually goes on your record. So if you just receive a notice, and let's say it's a 3-day pay or vacate, you have 3 days to vacate the property. If you leave that property by the 3rd day and you're not there on day 4, an eviction lawsuit typically won't get filed. And so that eviction wouldn't be on your record. You just happen to have to move out in 3 days and find a new place to live in 3 days, which we find is very unrealistic for people. But at step 4, this is when a landlord will file an eviction lawsuit. And that's usually if a tenant has not vacated the property when they're supposed to. And when they file that lawsuit, the court will send you documentation, they'll send you court paperwork, and you have a number of documents that you're required to file on time in order to be able to engage with the process. One of those documents is called filing an answer to the complaint. And that answer is so important. If that does not get filed, typically a tenant, a defendant, will default on the case, which means that the landlord usually wins. And in those circumstances, a judge is going to determine, okay, landlord, everything you alleged is true. However much money you're wanting out of this tenant, however fast you want them to move out, I'm going to grant you that. And the tenant just has to abide by it. So filing that answer is really important. Once you receive that court paperwork, you're supposed to file an answer within 3 business days. And that answer has to be in writing. The thing about it being in writing, though, is you don't actually need to fill out the 7-page document that they send you. An answer can literally be written on a napkin. The important thing is that you get something filed with the court on time. And the nice thing about filing an answer, even though you have to do it really quickly, is that it doesn't need to be perfect the first time either. You will have a chance to change your answer if you need to. What really matters is getting it filed. And we have people call us all the time. It's day 3. I've got to file my answer by 5 o'clock today. And we don't have the capacity to fill out the paperwork for folks or get it filed with the court for them, but we can provide you with resources about which court to file it with, what email address it needs to go to, give you general information about deny all your landlord's allegations, and just get it in on time. You'll have a chance to change it if you need to. Just keep in mind that filing that answer, if you do it on time, that means that you get to engage with the process and you will be granted an occupancy hearing. So when we get to step 6, this is going to be the hearing. And I mentioned that we often represent people in these hearings. And I don't know how else to describe these situations except that they're kind of icky because of what happens to people, and that most of the time when a lawsuit starts, it's really difficult to prevent an eviction in Utah. As I mentioned before, the best we can really do is try to negotiate how much financial burden people will have when they come out of this. And I always say this to people just to temper expectations. The law is not on tenant's side in this state, and attorneys have to work within the law and what they're able to do with the law to help people who are going through an eviction. That hearing, the occupancy hearing, will happen within 10 business days of you filing your answer. And so an example is Salt Lake. Eviction matters are always heard on Tuesday, every single week in court. Not quite sure what the system is up here in Ogden, but it will be within those 10 days. And you as a tenant must show up to that hearing. The judge will determine that in the hearing. Okay. Yes. And you will get additional paperwork with information about your hearing as well. So you should keep an eye out for that. I actually think it can be emailed to you. I'll talk about service of process in a bit, but the rules get a little bit loosey-goosey after the notice and the summons. So I believe that the hearing information can actually be emailed to you or mailed. It's just really important to keep your eye out for that. And so that's the process. So let's say you're in a hearing and the judge grants you 14 additional days to stay in your unit. By day 15, you need to be out. Whatever timeline they lay out for you is really important to pay attention to. Do you have any questions? Okay. Oh, and on this document, there are some definitions because when you get all this court paperwork, there's a lot of legal terminology that most people can't understand. I certainly didn't understand it when I started with PLA. So at the bottom here, we just have some definitions. Treble damages. I'll talk about those later, so I'm not going to go into that right now. The summons and complaint is when you'll get paperwork and the complaint's going to tell you why the landlord wants to evict you. And the summons is going to tell you how long you have to respond to that eviction. And that's at the point where you need to file that answer. And then a default judgment occurs when you either don't file your answer or you don't show up to your hearing, and the landlord is going to win that case. An occupancy hearing, we talked through that. And an order of restitution is basically a landlord will ask a judge to grant them full control of their property again. So when a judge grants an order of restitution, they're saying, yes, landlord, on X day, you have full control of your property again. And we'll talk a little bit about what happens if you violate that order of restitution and get locked out of your property. But take this with you and share it with your friends because we actually developed this. There is a form on the Utah court's website, but I as a non-attorney have looked at that and didn't understand it. So we hope that this will be helpful for you. Okay, so the eviction notice. We're not at the lawsuit stage yet. You don't need to file an answer yet. You don't need to attend a hearing yet. You're just getting a notice posted on your door, given to you by your landlord. A landlord has to deliver it to you personally, so they actually put it in your hands. They can mail it as certified mail. If you are not at your residence, they can leave it with someone of suitable age. Or they need to put it in an obvious place on your property. And the most common way we see a notice served is it's taped to your door. Yes, it is. And I understand what you're saying, but this is how the law says the landlords have to serve it. So going back to what I said about, keeping in contact with your landlord is really important. And I'll talk a little bit more about that. But if you get a 3-day pay or vacate as an example, if you don't leave within that 3 days, if you're still there on day 4, that's when the court process and the lawsuit will start. If you leave within those 3 days, usually nothing else will happen for that eviction. So there are actually various types of eviction notices in Utah. The most common, I said, is a 3-day pay or vacate, but there are others as well. There's a 3-day comply or vacate, which basically a landlord is going to give you the option to comply with your lease. This type of notice is usually given if you violated your lease in some way. They're giving you a chance to comply or leave within those 3 days. A 3-day notice to vacate for lease violation or nuisance is similar. A 5-day notice to vacate at will. This typically often happens when there's no written lease or oral lease. An example might be that a grandmother has allowed their grandchild to live with them. There's no oral or written lease, but they need to evict that person for whatever reason. This might be the type of notice that they use. And then there's a 15-day notice to vacate. Utah allows what are called no-cause evictions. We often see a no-cause eviction when, as an example, a developer buys a property. They want to rehabilitate the whole property, and so they evict everyone when their leases run out. And that's a way to, I know, I see some head shaking and it's gross. But just FYI, Utah does allow for that, and it's the no cause notice to vacate that people will get in those situations. Have any questions so far? I mean, it's really case by case, but I'll give you an example of, so there's a law in Utah, it's called the Fit Premises Act, that basically outlines the conditions that a landlord must provide in a unit for it to be habitable. Those include things like heat, electricity, water, etc. So in theory, Utahns have the right to habitable housing. The problem is that there's really no teeth to this law. There really are no levers or mechanisms that tenants can use to make their landlord comply with that statute, the Fit Premises Act. So let's say you're a tenant and you are, I don't know, your plumbing broke and you are swimming in sewage. Technically, you have no mechanism to make your landlord comply and clean up your unit. They could make you continue living in those conditions. And a landlord can cancel your lease if they decide to. Like if you complain too much about lack of heat or the sewage you're swimming in, they can cancel your lease for no reason. You could try the health department. If you engage with legal services, like if you're going through an eviction and you've had black mold in your residence and you have one of our attorneys, and as an example, representing you, they can talk to the conditions of your unit when they're negotiating the case. But also, we commonly hear, I'll just withhold my rent until my landlord fixes this. There are really no reasons in Utah that you can legally withhold your rent. And so it's not something that we advise doing. It will usually lead to a 3-day pay or vacate notice. I will say, I know that you're probably going to walk out of this room feeling hopeless. It's common that we do these presentations and the mood in the room just gets more and more somber as we progress. But there's not enough awareness about these issues, right? So creating that awareness, educating people on these issues. Our legislature, there's a small group of people controlling that conversation. And those of us on the ground, those of us with lived experience, need to apply pressure for any change to happen. So I know it's depressing. These are examples of what notices look like. So if you get a document that looks like this as a tenant, it's really important. It's important that you engage. If you get a notice, an eviction notice, and you want to stay in that unit, you want to prevent that eviction, however possible, one of the best ways to do that is to get in contact with mediation services. I'll talk through what those resources are in this community. Cody actually runs that program here in Ogden, but the best way to prevent an eviction is before the lawsuit is filed. But this is what the notices look like, and it's important to pay attention to what type of notice it is. Is it a 3-day notice, a 5-day notice, a 15-day notice? Because that will tell you timeline is, how much time you have to move out, engage with the process. So it's important to read the paperwork. Oh, we've had experiences with clients whose small, like young cousins or children got served with the notice because the rule is just a reasonable age. What is that? In those instances, that notice didn't always make it to the adult in the household. So just something to be aware of. So I just want to emphasize court case time sensitivity. This process moves really fast. You don't have time to freeze or flee. It's really important that you engage with the system if you are able to, or you leave your unit. And there are resources in the community to help you if you are in these situations. So a landlord serves you notice, you've been given that notice, and you have a number of days to comply, 3, 5, 15, whatever it is. And you vacate or you don't, and you might end up in a lawsuit. If you end up in if you don't vacate, the landlord can then file a summons and complaint. That's when the lawsuit starts. And then when you're served with that summons and complaint, you need to file your answer within 3 business days. And after that point, after you file your answer, that hearing will be within 10 business days. And then the rule in all of these hearings is that a tenant is always given 3 days to move out once that hearing concludes. But we, with our attorneys, are sometimes able to negotiate more time for folks. But just keep in mind that the rule is always 3 days. And then the landlord, after you move out, they're going to inspect your property and they're going to initiate debt collection on any damages. Okay. There are various options for you. So you can represent yourselves. We do see pro se tenants often. Actually, the majority of tenants in this state go unrepresented for various reasons. I'm happy to talk to that if you'd like me to. But keep in mind that when you do represent yourself, you have to abide by all the same filing rules that attorneys do. Most people don't know what those are. And there's also a resource that's called the Utah Court Self-Help Center. They have tons of great resources on there. It's actually a really great tool. The problem is the site itself is hard to navigate. It's a little bit difficult to read. So if you want to access this and you just need help finding the right thing on that website, you can totally call our intake line and our intake coordinator will help you through that and find what you need. She's very familiar with that platform. And then I mentioned working with mediators. So we have a program here in Ogden. Utah Community Action, based in Salt Lake, also operates statewide. And their role is to be an objective party in those situations. So they will work with both landlords and tenants to come to a compromise. And there is also a resource called Utah Court Alternative Dispute Resolution. I don't think this is free though, but it is an option if you need mediation services. And then you can also secure legal counsel. If you have the means, you could hire an attorney. People's Legal Aid offers free representation to people earning up to 80% of the area median income, which is like a weird way to measure brackets that people fall in for their income in the community. Just know that almost everyone who calls us falls underneath that threshold. So we almost always provide free services. Consultations will be free to anyone though. And when you do secure legal counsel, the attorneys are required to file the relevant information. They're required to present you with all of your options and what that could mean for you. They'll negotiate with the opposing counsel, so the landlord's attorney, so you don't need to do that. They'll attend hearings and negotiate on your behalf. It can do a lot for people who don't understand the court system or rules about how to engage. But when you do have a lawyer, it's important that you engage with them. Answer the phone calls, the emails, the text messages, whatever. We can't help you if you don't engage with us. Sometimes they will represent themselves. But in 2020, there was a statewide study done that showed that 95% of tenants did not have representation, and the majority of landlords do. Not all landlords do, but there is an imbalance. In Salt Lake, for the occupancy hearings, the rule is that if a landlord is representing themselves, the tenant will too. It just levels the playing field. But in general, most tenants don't have great access especially when we get outside of the Wasatch Front or Salt Lake County and into more rural parts of Utah. Access to services is pretty limited. It can be, yeah, absolutely. Having legal representation, if you're a tenant or a landlord, really gives you a step up. 95%. Yeah, that study's from 2020. So this is what a summons and complaint looks like. This is the court paperwork. You're going to have usually a case number here. It's going to tell you who the plaintiff is. If you are the tenant in this situation, it's going to have your name under defendant. You'll often have whoever the landlord's counsel is. So an example is the law office of Kirk Cullimore.
For everything in Utah, right?
Yes, a lot. And they are the biggest landlord attorney firm in the state. And then here it's going to tell you where this is taking place. So if you're getting evicted in here in Ogden, it's going to say in the 2nd Judicial District Court, Ogden, Utah. When you call us, if you've been served with a summons and complaint, it helps us a lot if you have this paperwork available and you can tell us what this civil number is. Because when you give us that case number, we can look up everything that's happened in that case in the court system. No, you're fine. It might not be a summons and complaint. This should always have a case number on it. It's usually 9 digits. When you get served with this, you have 3 business days to file that answer to the complaint, or the landlord wins. Any questions yet? So I'm not going to touch on mobile home park law today because it's a weird area of law. Some landlord-tenant laws apply, but others don't. And so if you have questions about that, I would actually recommend calling our intake line. You can speak to one of our attorneys. We're happy to do
You guys have had a client who all of these that you explained happened.
Mm-hmm.
She had the paperwork, but when I went to the park and they wouldn't want to give us any information, and the sad part was like she was only Spanish speaking and they wouldn't want to speak to anyone else. Like it had to be.
Oh, goodness.
Or the office say we can talk to a third party. We will have to talk to you. I'm sorry, you don't speak English. So I went there and I scanned you to translate. And they didn't really do anything. And I don't know, like maybe I didn't understood the paperwork. If it was like if they needed an answer or something, but she opted for leaving the trailer park and she had to sell her. But it was like super cheap. They didn't pay a lot, and they charged her with the attorney fees.
Yeah. So I can also send a link to a video for Cody to distribute as well. Does anyone in here watch John Oliver? Okay, he did a great clip. If you just want a surface level view of mobile home park law and something that's going to make you really mad, it is a great clip to watch. Mobile home parks are really challenging, and yeah. Yes, they are. They are high in cost, and you own the trailer but not the land, and you can't always move the trailer. So going back to service of process, for your initial court documents, it's required that they are personally served to you. If you cannot be found to actually be served personally, the documents can be given to an adult who resides at the address. Other court documents, I mentioned that it gets a little loosey-goosey after a certain point. So after those initial court documents, it can be served to you through email or paper mail. It doesn't necessarily need to be delivered in person. Just FYI to all of you, we hear from clients all the time, I wasn't served properly. It's actually really difficult to use that as a defense because it's really hard to prove. And the burden of proving that is on the tenant. So just keep that in mind. There are different rules. Yes. So the initial court document, so like your summons and complaint, is going to be personal service, but information about your occupancy hearing can be through the mail or email. I recommend getting in touch with us. We'll get you scheduled. We'll get you scheduled for a consult. So if you haven't gathered already, there is a lot on the line for people in these situations. If you missed your deadlines for filing documents or you missed your hearings, the landlord's going to win. Just keep that in mind. And so let's say you missed a hearing, but you were in the hospital and literally you could not make it there. A judge can set that ruling aside in those situations, but you do have to prove that you had some sort of extenuating circumstance like that. There are different types of landlord requests in these situations. I mentioned an order of restitution. This is when a landlord wants full control of their property back, and when that order is granted, and you violate that order, a landlord can change the locks on you and prevent you from entering. So you don't have to answer to the order of restitution, but you do need to comply with it. And then there are damages as well. So you might have heard the term treble damages. We also call them punitive damages because, yes, it is when your debt can really rack up. They are a punishment. In the civil legal system, treble damages are designed to punish you for doing something. There is no other area of civil law in Utah that uses damages like landlord-tenant law. So lots of damages can be trebled, but the most common we see is for daily rent. So let's say you get a 3-day notice to pay or vacate. You're still living there on day 4. You are technically unlawfully on that property, and treble damages will start accruing at 3 times the rate your daily rent. And then there are also physical damages. So you ripped out the plumbing, or I don't know, there's a hole in the wall. They'll also assess property for those kinds of damages. So just some things to keep in mind. In general, we tell people best thing for you to do is get out. Even when in a hearing we negotiate, we're able to get 2 weeks for someone or 30 days sometimes. Be ready to go, and keep in mind that even when we get that extra time, treble damages accrue still for that entire time until you leave. So it's really just best to move out as soon as you possibly can. Missing deadlines or hearings, again, a landlord's going to win. And it's not over until it's over. Just because you've moved out, the landlord is still going to evaluate the property, and they will still sometimes seek compensation. Not every eviction lawsuit goes to a debt collection lawsuit. We most often see them filed through the law office of Kurt Cullimore. So it's just important to keep in mind, like, I've been evicted, I might end up in a debt collection lawsuit, but I might not. And I'll talk about the timeline on that because you have to be on your toes for several years looking for or keeping your eye out for that lawsuit. Lockout procedure. So judge grants an order of restitution, says you have 14 days to remain on the property. You're still there on day 15. Landlord can change the locks. They can lock you out of the property because you no longer have a right to be there. They might engage the sheriff or a constable to remove your property. They can store it at an offsite location. And then they have a period of time they have to wait before they can sell or auction off your property. So the first period of time is you have 5 business days to get some of your property back without paying for anything. That includes financial documents, identification, medical documents, clothing, things like that. And this rule, this 5 business days to get those types of property back without paying a fee, that's like codified in law. It can't be contracted out. So you have 5 days to get some of those 5 business days to get some of those type of property back without paying a fee if you're locked out. And then a landlord has to wait 15 calendar days before they sell or donate your property, throw it away, whatever. They have to wait for you to make a reasonable effort to get that property back. This 15 calendar days. So yes, I know. Sometimes, not always. It's so important to, yeah. So like here, if you're locked out, you have 5 business days to get some of it back without paying anything. But a landlord has to wait 15 calendar days before doing anything with your property. Calendar days business days is Monday through Friday. Calendar days are all days of the week. So this 15 calendar days technically can be contracted out. We see a clause in the Cullimore lease says something like we can place a lien on your property if you get locked out until we get any rent, like back rent paid back, or you pay damages to the property. But we actually never see that executed in practice. Yes, but just know it can be in a lease. Yeah, 15 calendar days pass if the landlord has not already sold or donated your property. You have an additional 15 calendar days to get your property back if you provide one of the following: a police report or protection order if you're in a domestic violence situation, verification by a medical provider that you were hospitalized, or you died and your family is trying to get your property back, they can provide a death certificate or an obituary. Let's say the first 15 calendar days pass, and on day 16, they still haven't done, or day 16, day 17, whatever, they still haven't done anything with it. You have an additional 15 calendar days to get that back if you provide these things. So if you don't have these things, too bad, sorry. When they auction it off or sell it, they don't have to sell your property for what it's worth. So let's say you have a $2,000 couch, they sell it for $200. That $200 gets applied to your debt owed, but just keep in mind it doesn't have to be for what that's worth. Okay. So this 15 calendar days to get your property back, to make a reasonable effort, we see a clause in the Collimore lease that basically says we can place a lien on your property and refuse you getting your property back within these 15 calendar days until you pay back rent or pay for damage to the property. So the eviction lawsuit is over. Now what happens? The landlord will inspect the property. They'll determine how much damage there is to the property. They might initiate debt collection, and this is what we call a residential debt collection lawsuit. So when you move into a unit, it's really important that you document the state that that unit is in. Take pictures, complete the move out checklist they give you. Anything you can do to document what condition that place is in when you move in is really crucial for when we get to this stage of debt collection and a landlord assessing damages. Because if you have no way to show what condition that unit was in when you moved in, a landlord has a lot of leeway, exactly, to claim whatever they want. So any true crime fans in here? Because when you move into a place, you're like documenting a crime scene, right? Like take pictures of everything. So your eviction lawsuit ends. Under Utah law, a landlord then has 6 years to file a debt collection lawsuit on your eviction debt. And there is interest accruing in those 6 years. The highest interest rate we see is 24%, executed by the law office of Kirk Collimore. If you don't walk out of here mad, I haven't done my job. Yes, we actually did not talk about that, and I can't believe I didn't mention it because we always bring it up. It is so important that you keep a current address with the court because a landlord is only required to send information about a debt collection lawsuit to the most recent address on file. That could be the address you were evicted from. And so we get people who call us and they're like, I gotta go to this hearing. I don't know what it's for because they never received paperwork about the debt collection lawsuit. Highest interest rate we see is 24%. It might not always be that high. The landlord can really set their own interest rate. Then it goes to collection, right? So they have 6 years. It adds more time. So they have 6 years to file the lawsuit. And then they have an initial 8 years after that to collect on the debt, but they can renew the judgment for another 8 years. So in effect, you could be paying on an eviction lawsuit 22 years after you were evicted. So I'm not going to go into it a lot because a lot of the ideology and theory behind the right to contract and the right to property go back to Utah's incorporation as a state. We are actually launching a podcast in the next few weeks. We are actually going to do an episode on why is it like this. We have a social media page, so it'll probably be posted there and on our website. And I'll make sure Cody has that information. Yeah, but it's just plautah.org. But we'll talk a little bit about like the and why the right to property and the right to contract are enshrined in our Constitution as a state, and why it is really difficult to get around issues of contract, and because we have a right to contract, and Utah has a no cap interest rate rule, which also goes back to our incorporation and banking law. It's very complex, but we will provide an episode on that. So make sure You can see that. Utah is a contract law state. There are some rights that you cannot contract away, but there is a report that there's a group called the Justice Lab at the University of Utah's Law School. They did this whole report around eviction laws in Utah, looked at leases and what we see. We do sometimes see contracts that waiving rights that you're not supposed to, but I can make sure you have access to that report as well. It's a little bit long, but if you're interested in reading it, compare this system all the time to payday lending, which is also predatory. And we, as an example, we just helped a client, DV survivor, single parent, had left a lease because of a DV situation, ended up in a debt collection lawsuit for it years later because they couldn't reach the other party who had remained on that lease. The landlord was trying to claim $12,000 in damages, but we were actually able to use a really unique defense in that case and got all of that debt wiped off her report. So she didn't need to pay back anything. But we commonly see people who come to us with thousands of more dollars in debt that's mostly interest when they're in the debt collection stage because it just sits there. It is crazy. You know, one way you could try to get ahead in this kind of situation is try to pay it off before a lawsuit ever gets filed. I mean, that's very true, but you could always call PLA and we can help you liaise with the landlord to set up a payment plan, maybe to negotiate some of that debt down. We're past staying in the unit now. Yeah. We're way past. Also, keep in mind that if you call your landlord's office and you acknowledge that or your previous landlord's office, and you acknowledge that you have that debt, it starts the clock over. So if you want to engage and try to set up a payment plan and negotiate with the landlord to maybe get a lower settlement, contact us, contact Utah Legal Services, and we'll work with you through that. Garnishments. Also part of the debt collection process. So I mentioned up here that we get people calling us who had no idea they were in a debt collection lawsuit because they may not have received the paperwork. Same rules apply in debt collection lawsuits as evictions. You've got to file your paperwork on time. You've got to show up to your hearings. If you don't, you'll default. And if you default, a garnishment, you pay back a debt when you haven't engaged with the system. So when your wages are being garnished, there are two types. There's a writs of continuing garnishment. This is used to garnish wages. And in these situations, it is not you as the individual that's responsible for sending that money, it's your employer. So for PLA, if I had someone on staff who a collector was trying to garnish wages, they would serve me as the employer, and I would be responsible for taking those wages out of payroll. But keep that in mind, if you ever get a paycheck and you're like, why are 25% of my earnings missing? It might be that you're getting garnished. And then there's a writs of garnishment, and this is used to garnish other types of property like a bank account. Generally, income from your job is not protected from garnishments. There are certain types of protected incomes, however, and those include Social Security, public assistance, disability, unemployment, workers' comp, medical, and veterans cannot be collected. A collector cannot garnish on those types of income. So we sometimes have clients that we call collection proof, and they're often the only income they make might be Social Security or disability. And so in those situations, a collector is never going to be able to get that debt back as long as that's the only income that they continue to receive. If someone was receiving disability and they went out and got a job and was receiving other types of wages, those wages could be garnished. I'm not going to talk through these. I am going to send Cody has this. These are all live links, so you can actually just click on it and go to the resource yourself. And then best times to collaborate with us, get in contact with us, the moment you get a notice. So you see it on your door, call our intake line, call mediation services, call Utah Legal Services. It's in your best interest to engage sooner rather than later. Let's see, easiest way to call us, it's on that postcard I mentioned. Please take that with you. If you are someone who is, you have a case manager who works with you, as an example, if you're currently living at the Lantern House and you don't feel like you can call us yourself and engage with the attorney yourself. That case manager can totally be there with you to advocate for you. We just need permission from the actual client that that person is able to be there. And we do have instances like this where we have folks who get in touch with a case manager, and that case manager continues to help them through the process. We're not case managers. We have attorneys on staff, but the Lantern House has case managers. So if you're living at the Lantern House and you have a case manager, they might call with you. Or maybe you have a domestic violence advocate that you want on a call with you. Anyone like that, that's totally permissible. There are various other legal services available besides us. So we only work with tenants. We only deal in landlord-tenant law for evictions and debt collection. We don't represent landlords, but that is all we do. We don't do family law. We don't work in protective orders. We don't do immigration, anything like that. But there are services in the community that do. These are also live links, so I'm not going to touch heavily on them, but Utah Legal Services is our sister organization. They do have income requirements, and they cannot serve people who have undocumented or mixed documented status. So just keep that in mind. Nonprofit Legal Services of Utah is not free, but it is a reduced rate if you need an attorney. And generally, they don't do landlord-tenant law. They typically refer people to us, but they deal in other areas of law. We are the only law firm in the state that can represent that population going through eviction or debt collection. ULS can't because it's really dumb. They're funded by the Justice Department and they're not allowed to. Oh, they do immigration law, but like if you're a tenant and you don't have any sort of documentation, they can't serve them, but we can. Oh, you're fine. The Utah Bar Association provides what's called a modest means program if you need an attorney, but you don't make tons of money. Timpanogos Legal Center deals in family law. They actually have a really cool project going right now where they have non-lawyers helping people fill out paperwork for protective orders. So they'll do that. Disability Law Center deals in fair housing. Let's say you feel like you've been discriminated against as a tenant. Your landlord is evicting you because of your race, as an example. People's Legal Aid will help with the eviction only. We don't deal with fair housing, but we will refer that person to Disability Law Center for that fair housing issue. They're two separate problems. Fair housing is covered by some federal laws. Eviction laws are very specific to Utah. There's not a lot of overlap between the two, and both law firms have to touch both of their respective areas. The Pro Bono Initiative is a group through the law school at the University of Utah. It's basically a resource. They provide free legal clinics for various areas. They have immigration, family law, landlord-tenant law. We worked with them to launch that. And they happen every Tuesday of the month on a rotating schedule. Basically, you could go. They do appointments or walk-ins. You could go, you could sit down with a law student and just get some basic advice about your situation. They're not going to solve all your problems in that 30 minutes, but it's a really good resource for giving you some direction with your legal problem. And okay.
I asked if there's any questions online, but they said no.
No.
Thank you, though.
If you don't mind taking a second, and if you have the ability to scan a QR code, it'll just take you to the survey that basically asks you, what do you think of this training? What could have we done well? What could we have done better? And we really appreciate your feedback because we're constantly improving it. Actually, they can, and they can raise the rent however much they want. There are individual cities, so like Ogden or Salt Lake City, any city across the state is not allowed to set rent controls. The Utah legislature in 2006 basically prohibited that, and there are no regulations around how much property owners can raise rent. And we see this situation often where the rent gets raised so much that that person can no longer afford to live there. And there are also no other affordable and available places to go in the community.
housing.
Yes, there is low-income housing. Yeah. Get connected with case managers in these situations. The rules between private owners and then properties that do have some sort of low-income housing component have different rules they need to follow. And also rental assistance, if you haven't already gotten connected.
I do recommend applying.
Yes, apply. No, but there is a report that exists that I can include in my resources to Cody. But what you said about not Googling what the laws are, in general, you might get information that's from the wrong state. You might even get Utah law information, but it's outdated. You just never know if it's current law or even relevant to Utah. You can end up with wrong information. So get in touch with a trusted source. We're a good place for that, but there are also other sources in the community. Utah Legal Services is one of them. Cody might be able to help with some things. Internet searches are not always accurate. Yeah. But Utah has one of the most draconian set of laws in the country. Yeah, Nathaniel can't give legal advice, but he can give general information about the law, what it says, what it means. He is an attorney. He is licensed here in Utah, but because he works for the courts, he's supposed to be non-biased and can't give legal advice, but he's very knowledgeable. Giving anyone the wrong information could mean really bad consequences for that person. Yeah, it was my pleasure. Thanks for coming. Thank you for your questions.